Welcome to Module 4, Legal Foundations for Creative Entrepreneurs. This first lesson is about intellectual property, the legal value inside everything you make. Your creativity is your capital. Let's learn to protect it like one. Let's begin. Let's start with the foundation. What actually is intellectual property? Intellectual property, or IP, means creations of the mind that the law recognizes as yours. It gives you the right to control how your work is used, shared, or sold. For a creative entrepreneur, this is often your most valuable business asset, worth more than your equipment, more than your premises. A logo, a song, a design, a product idea, everything you make carries legal value worth protecting. And protection means control, the right to decide who may use your work and how. Your first exercise is the IP asset inventory. Take 10 minutes to list everything your business owns: your works, your brand, your processes. You can't protect what you haven't named. EU law gives you 4 tools to protect intellectual property. Think of them as 4 pillars. The first is copyright. It protects your original creative works, books, photos, music, film, software. The second is trademarks. They protect your brand identity, your logos, names, slogans, and packaging. The third is patents. They protect inventions and technical innovations, devices, processes, formulas. And the fourth is trade secrets. They protect confidential knowledge, a recipe, an algorithm, a client list, valuable precisely because it stays private. 4 legal tools, each protecting a different kind of value. As a creative, you'll rely most on the first 2, so let's look closer. Let's talk about copyright, your automatic shield. It's the most immediately relevant right for most creative professionals. And here's the good news. It's automatic. Protection exists the moment you create the work. You don't need to register it or add any symbol. Under EU law, that protection lasts a long time, your life, plus 70 years. Copyright gives you 2 kinds of rights. Moral rights, the right to be credited and to object to distortion of your work. And economic rights, the right to earn from it by reproducing, distributing, or licensing it. But one warning: when you work with clients or collaborators, always clarify who owns the IP in writing. Silence is not consent, and an unwritten assumption is where most creative disputes begin. Copyright is automatic, but automatic doesn't mean effortless. To make protection real, take 3 moves. First, document. Record your creation dates and keep your originals. If ownership is ever questioned, that record is your proof. Second, register. Copyright is automatic, but your brand isn't. Register it as a trademark wherever its recognition and value justify it. Third, assert. State your ownership clearly in every contract and license you sign. Don't leave it to assumption. Copyright is automatic, but fragile. These 3 moves: document, register, assert, turn a legal right into real, defendable protection. Next, trademarks. While copyright protects your creative work, a trademark protects your brand. That's the name, logo, slogan, or symbol that makes your business recognizable to customers. What can you register? Names, logos, slogans, even distinctive shapes and colors. You can protect it in a single country or across all 27 EU states at once. with an EU trademark registered through the UIPO. But unlike copyright, a trademark isn't automatic. It requires registration and renewal every 10 years. Your second exercise is a trademark search. Look up your brand name in the UIPO database and check for conflicts. And remember, use it or lose it. Non-use for 5 years can lead to your mark being canceled. The third pillar is patents. These are less common for creatives, but vital for those who mix creativity with innovation. Product designers, tech-enabled makers, inventors. A patent protects something new, inventive, and industrially applicable. So what can be patented? New inventions, technical innovations, industrial processes, and functional product designs. And what can't? Purely artistic works, abstract ideas, mathematical methods, and pure aesthetic creations. Those belong to copyright, not patents. A patent lasts up to 20 years from filing, across 40+ countries, through the European Patent Convention. But there's a catch. A patent requires full public disclosure. Sometimes keeping something a trade secret, a recipe, a process is the smarter, more strategic choice. Ask yourself, does my business involve a unique process a competitor could replicate? If so, it may be worth talking to a patent attorney. Let's put it all together as a roadmap, 5 steps to a complete IP strategy. 1. Foundation. Know what you own before someone else tries to claim it. 2. Copyright. It's automatic but fragile, so document your work and assert your rights. 3. Trademark. Register your brand to own your identity in the market. 4. Patents. Consider them when your creativity crosses into technical innovation. And 5. Enforcement. Be ready to defend your work because protection is only real if you're willing to act on it. And if someone does copy you, document everything first: screenshots, dates, links. Then send a cease and desist letter, which often resolves it early. If that fails, escalate to your national IP office or to mediation, which is faster and cheaper than going to court. Protection only matters if you can spot when it's being crossed. So let's talk about infringement. The first sign is unauthorized use: your images, text, or designs used without your permission or a license. The second is copycat, products imitations of your product or brand that ride on the reputation you built. The third is unlicensed reproduction: your music, your content, or your work copied and shared without a license. The reassuring part is that the law is on your side. The EU IP Enforcement Directive sets minimum standards across Europe. That includes damages, injunctions to stop the infringement, and recovery of your legal costs. Repeated or commercial-scale infringement usually needs a lawyer, but for most everyday cases, a documented, firm response resolves it early. If you're wondering whether IP protection is really worth the effort, consider the numbers. Since 2017, EU trademark registrations have surged by 131%. Creative businesses across Europe are registering their brands in record numbers because it pays off in revenue and growth. And it's efficient. One EU trademark covers all 27 member states at once on a 10-year renewal cycle. So don't think of protecting your IP as a cost. Think of it as building an asset, one that can grow be licensed, and one day even be sold. So what do you actually do when someone copies your work? Follow 4 steps in order. Step 1, document everything. Screenshots, dates, links, copies. Before you do anything else, build your evidence. Step 2, send a cease and desist letter. It's a clear, formal request to stop, and it often resolves the issue early and cheaply. Step 3, if the letter is ignored, file a complaint with your national IP office or the court. Step 4, consider mediation. A neutral third party is far faster and less costly than full litigation. The principle is to escalate only as far as you must. Most infringement stops at a documented, professional first response. You rarely need to reach a courtroom, but knowing you're ready to defend your work is what makes the early steps work. That's lesson 1. You can now recognize, name, and protect the intellectual property in your business. Next lesson, we build the legal scaffolding around it, contracts and business structures. This project is funded by the European Union. Thank you for watching.